you very much. I just thought I'd start with just giving you a bit of a timetable as well in terms of the legal process. And my task is to talk about the Assisted Decision-Making Capacity Bill, which was published in 2013. And we're talking about updating legislation, the Lunacy Regulations Ireland Act of 1871, where we talk about idiots, lunatics and people of unsound mind. And that is still our law. My own view is that any organisation or society have to work to rules, but those rules must be fit for purpose. And if they're not fit for purpose, it is very, very difficult to actually get all of the other issues in place and correctly. So again, a bit of a timetable. In 2001, the Law Reform Commission started work on law and the elderly at that stage. And we published a Law and the Elderly report in 2003, launched by the President of Ireland, President McAleese, who at that stage had her father-in-law in the Aris, suffering from dementia. So very interesting, and I remember also at that stage being told by a very senior civil servant, this is all pie in the sky, this will never happen. And I said, no, it will, it's going to happen. The Commission went on, published a consultation paper. One of the issues that kept coming out at us at that stage was the issue of capacity. It wasn't defined in the 1871 Act. Hasn't really been defined in Ireland until Mrs. Justice Mary Lafoy in the FK case in 1997 defined it, and I'll come to that in a minute. In any case, we looked at the issue of capacity, published a consultation paper in 2006, published a report in 2007, Vulnerable Adults in the Law and the Issue of Capacity. A draft scheme was published in 2008 by the government at that stage. Got some of the issues right, but certainly was far from ideal. And then the Commission, one of the other issues that kept coming out from that study was the issue of advanced healthcare directives, the right of people who had a capacity issue to consent to and refuse to medical treatment. And we worked then on advanced healthcare directives. And subsequent to that then, another issue was the whole question of caring and caring in the home, and the Commission published its report in 2011 proposing the Fair Deal scheme be extended to all people in home. And we had the bill then published in 2013 with then the draft scheme for advanced healthcare directives published in early 2014. And we're now at 2015, so it takes a long, long time. And if you have a law that's not fit for purpose and trying to get everything else in place, we have to have the basic rules. And what amazes me all the time is that it's not high on most people's agenda that we actually do change the law. And we, even in spite of Ars Retracta, we were promised we'd have debate in the Oireachtas in January. And January has come and now going without that debate. So, and we had PQs in the Dáil last week, and the Minister saying it'll be done in this session. So anyway, we move on. So anyway, I just thought I'd give you that background because I think the whole time scale, it just drags on. So I'm going to really talk about the bill, and I'm going to talk about how the bill suggests that capacity is assessed. General principles, I won't go into detail on that because I know Mary Keys is going to talk about that later. And then the various different decision-making mechanisms, and then the draft scheme for advanced healthcare directives and some other issues. So just very briefly looking at the existing structures, we have the presumption of capacity at common law. So we have this legal principle that you presume that people have capacity unless the contrary is clearly indicated. And also one has to be careful about that because certainly from the House of Lords report in England on looking at the presumption of capacity, which is now in their legislation, and the presumption of capacity will be written into our law. is that people use that presumption to avoid supporting people with disability. So they presume you have capacity, therefore you don't need support. So that's an issue that we have to address as well. Currently we have next of kin with no general authority, and yet all the time we have next of kin being asked to make decisions or consent to treatment or whatever, where they have no legal authority to do so. Certainly no emphasis on the people's rights or wishes at all in the current legislation. I've mentioned the 1871 Act, which is the wards of court legislation. Very much if a decision has to be made, and normally arises certainly with older people in my experiences, where at that awful stage where they've been in the acute hospital, they're being discharged and it's nursing home, they've no capacity, they're taken into wardship, or they, in terms of property and money, but nothing about their well-being, which is a huge issue. And that was when the scheme of the bill in 2008 was published. The Commission had gone to a lot of trouble to emphasise the whole question of the social and personal well-being of the person, apart from property rights. And yet, when the scheme of the bill was published, the jurisdiction of the courts was based on property ownership yet again. Thankfully, that's gone in the current bill. There's no participation at all by the person, the subject of the application. Their decision-making capacity has been taken away from them, and they don't even appear in court. There's no review of their position. Then, in relation to enjoying powers of attorney, there's no provision currently in the 1996 Act for healthcare decisions, for appointing an attorney to make healthcare decisions. And for advanced healthcare directives, while they're legally valid and recognised, we've no legal framework in which they're understood or interpreted, and this gives rise to huge confusion. I also think it's very worthwhile to look at our international obligations because in the context also of where we are. We have our Constitution of Ireland, and that actually spells out very clearly that all citizens are equal before the law, and the state has to have regard and due regard to differences in capacity. But rights are for everybody, all people in the state, and yet for many years we have ignored that. With the European Convention of Human Rights, which again, the right to dignity, privacy, to be treated properly, not to suffer inhumane and degrading treatment, and all of that. And in 2003, we passed legislation to say all our laws would be interpreted in the light of the European Convention. And yet we have practices like chemical restraint in nursing homes where people are actually suffering inhumane and degrading treatment, which is not medical treatment, and other issues. And then the whole issue of privacy. I raised that in the Irish Attracta case, where very clearly that the employees in that case, RT, were very careful not to show the faces of employees, but the people with disability, what about their privacy? And in terms of their privacy was very compromised and their dignity was very compromised. And why, so how we treat people with disability is very open to question. Then we have the UN Universal Declaration of Bioethics and Human Rights. And what that is saying is following the Human Rights Convention and enforcing the rights of people that must be honoured in terms of consent to and the refusal of treatment, and also very clearly makes the point that those rights still pertain for people who lack capacity or have a disability. They equally have the right to consent to and refuse treatment, and state parties must have facilities in place to accommodate that. Then we have the UN Convention on the Rights of People with Disabilities, and effectively it articulates very clearly what our Constitution does say, and the question that everybody has legal capacity, legal rights, and there has been a huge confusion as on the UN Convention is the difference between legal capacity and decision-making capacity and mental capacity. But anyway, but equally the UN Convention talks about safeguards. And for older people, I feel that that's a huge issue in terms of abuse of older people. And if anybody looks at the studies of the National Centre for Protection of Older People in UCD, will see those studies there in terms of the huge abuse, particularly of older people. And on that point, I would say in relation to the law as well, that our bill, our assisted decision-making capacity bill, is catering for a huge different classification of people whose decision-making capacity is at issue. On the one hand, you have people with intellectual disability who you're trying to absolutely maximise their capacity because they haven't actually been in the situation where they were educated or got the benefit of training to try and maximise their capacity as they were growing up. On the other hand, you have a huge cohort of older people who had huge capacity, huge experience, and they're on the downward trajectory. And that is a challenge as well, and a challenge in relation to the safeguards, and all then the family dimension in relation to that. So we have the Council of Europe then, Principles Concerning Powers of Attorney and Advanced Healthcare Directives, which sets out that precedence, the right of autonomy and self-determination, and precedence should be given to people to pre-plan in advance and to put those systems in place. We have the Council of Europe then recommendation, which was finalised last year, re-emphasising, because it felt it was necessary to re-emphasise the rights of older people to dignity, privacy, and to encourage state parties to please put in place systems where older people could plan ahead. And the whole question of palliative care and the right to palliative care for older people. So very quickly, I'm not going to, because the time doesn't permit me to go into a lot of detail on this, but basically we're moving from a medical model, or should have moved from a medical model of disability to a human rights capacity model. So the emphasis on what a person can do rather than they have been diagnosed with a particular illness or cognitive disability and they can't do. So the whole emphasis is on the legal rights equal to others regardless of the disability. And of course then taking account of the different capacities that people may have. Very quickly, the outcome approach for assessment of capacity is usually where, in the medical context, where a patient might disagree. There have been a few cases on that. A patient might disagree with the suggestion or the advice of the doctor, and the doctor would assume then, or presume, that they lacked capacity. The status approach is where one decision is taken, our wards of court system. And I should say, in terms of our law here, I would also emphasise that the wards of court system actually is really the only system left in this jurisdiction that works on the status. We have all the policy documents and everything as a result of the Mary Laffoy decision in 2007, which actually set out in detail how capacity should be assessed in this jurisdiction. So it's there in the common law at the moment. It should be the functional approach. All the policy documents, the HSE consent policy, the Mental Health Commission's policy on consent and capacity, HICWA's policy, HSE policy, Department of Health, all based now on the functional approach to capacity. And yet, when it suits us, we fall back into the old ways of just ignoring that, and that's where the fundamental rule needs to be put in place. So the purpose of the legislation then is to promote and protect the human rights, which includes the right to inherent dignity, the right to privacy, bodily integrity, self-determination and autonomy, which are extremely important. So I won't delay on that. So who is the legislation for then? The legislation defines the person as who it's for is for a relevant person. And such a person is a person whose capacity is being called into question or may shortly be called into question in respect of one or more than one matter. So people are just at the cusp or at the borderline. And then a person who lacks capacity in respect of one or more than one matter. So they could have capacity for some decisions but not have capacity for others. It depends on the decision, it depends on the seriousness of it. And certainly the research would indicate that in terms of financial decisions, it requires quite a high level of executory capacity to understand financial transactions. And we can all understand that ourselves in ordinary everyday life. And that's where the huge financial abuse of older people comes in, where that capacity issue, you need that higher level of capacity, and then the family dynamics that come across that as well. So the legislation is also for a person who falls within both of those categories at the same time, but in respect of different matters. And I just make the decision between decision-making capacity there and cognitive ability. At the moment, most assessments are carried out on the basis of, has this person cognitive ability, where it should be, have they got the capacity to make the decision on the issue in question. So the legislation will provide that a person's decision-making capacity is to be construed functionally, time-specific, issue-specific, at the time the decision has to be made, taking into account the circumstances, etc. So the ability to understand the nature and the consequences of a decision to be made by the person in the context of available choices. And that is what is extremely important. Again, the House of Lords report last year indicated that when people there who have actually their 2005 Act in terms of the functional approach to assessment of capacity, the House of Lords inquiry found that people were not being given the choices, that whoever was assessing capacity was going in with a clean sheet and not actually assisting the person. And that is what is extremely important. So at the time the decision has to be made. And then the lack of capacity will be indicated where a person is unable to understand the information relevant to the decision, retain the information or use or weigh that information as part of the process of making the decision or to communicate the decision. Now again, there have been a huge number of cases in England where those three elements, the understanding the information, the retaining the information and weighing up the information, weren't all present. So you need those three elements because a person could understand information, retain the information even for a short time, but unable to process the information, and that's what's important. A person is not to be regarded as unable to understand how capacity is to be assessed. A person is not to be regarded as unable to understand information relevant to a decision if they are able to understand an explanation of it given in a manner appropriate to their circumstances. So if a person is deaf or has a capacity or a cognitive issue, then what help do they need to assist them in making the decision? The fact that a person is able to retain the information for a short period of time does not indicate that they lack capacity. Of course, if a person can't retain the information and can't retain the information, of course it indicates that they haven't capacity. Then information relevant to the decision includes the reasonable foreseeable consequences. And I've heard people speak about this before. And again, in reading the cases, it's the practicality of what is reasonable in the circumstances of the decision they have to make. And the available choices at the time the decision is, or failing to make that decision. In other words, in, say, medical treatment, do they know if I have this treatment, the benefits to me, the side effects of medication? If I don't have it, what is the consequence of that? And it's the civil law standard then test of the balance of probabilities of whether the person has capacity or not. And if it's difficult to really come down one way or the other, balance in favour of capacity and to maximise that. Then looking at the general principles that are set out in the legislation, they shall apply to everybody who is intervening with a person whose capacity is at issue. So before doing an assessment, at the time the intervention is taking place, every intervener must honour the principles, including the court making any decision or anybody else. So it's important. First of all, the presumption of capacity is there unless the contrary is shown. The relevant person shall not be considered as unable to make a decision unless all relevant steps are taken without success to help him or her to do so. And again, the cases in the UK are very indicative of that, and I'm sure Mary will highlight some of those issues. Making an unwise decision is not indicative of being unable to make a decision. And I would quote Mrs. Justice Mary Lafoy again, where she said the issue for the assessment of capacity was whether the person whether they misunderstood or had a misperception about the information which was relevant to capacity. But if they made an irrational decision for irrational reasons, it was totally irrelevant. So the fact that a person makes very unwise decisions is irrelevant. But the question is whether they understand the information and can process the information in order to make that decision. There shall be no intervention unless it's absolutely necessary to do so, having regard to the individual circumstances. So again, if a person may lack decision-making capacity, but there's no reason to intervene or whatever. They're getting along fine or whatever. It's not necessary. But obviously, in very many cases, it is necessary. It is necessary to get a consent, and it is necessary to intervene. But anyway, any intervention shall be in a manner that minimises the restriction of the relevant person's rights and minimises the restrictions of their freedoms of action. And again, recent Supreme Court case in England, the whole question of movement, supervision, control, people going out, being able to associate in a garden outside or outside going for a cup of coffee, and the whole question of that supervision. So to minimise the restriction on freedom of action. And very importantly, and this is one of the issues that the Law Reform Commission highlighted in detail had to be in the legislation, was to actually repeat the rights that are spelled out in the European Convention. So have regard to the need to respect the right of the relevant person to his or her dignity, bodily integrity, privacy and autonomy. And then there's duties then imposed on any intervener. While the principles are all set out that they must abide by, there are also the duties that a person must permit, encourage and facilitate the relevant person to participate, to improve the relevant person's ability to participate. Give effect insofar as practicable to the past and present will and preferences is insofar as they can be reasonably ascertainable. To take account of the beliefs and values of the relevant person. And again, I would make the point, you hear a lot at the moment in terms of people talking about, oh, must have the will and preferences and all of that. And people forget about the beliefs and values. And again, just to give some examples, will and preferences insofar as they're reasonably ascertainable. But again, looking at the case law in other jurisdictions, you will see it may not be possible to ascertain what the will and preferences are. There may not be family members around to give that information either. And the person may never have articulated what their will and preference was about a particular thing. So it can be very difficult. So I feel, particularly for older people, that their beliefs and values, their lifestyle, their life story, their history, and the pictures and the photographs they might have around them, they're the things that might help a person interpret what the older person's beliefs and values. So I would put an equal emphasis on the beliefs and values. And at the end of the day, and this is another whole debate which I can't get into, if you can't ascertain either, what do you do? And again, I would look at the Victoria Law Reform Commission, who says you look at the personal and social well-being of the person. That's another debate. So anyway, the intervener also has to take into account any other factors which the person would be likely to consider if they were able to do so. So looking on then to decision-making, the planning tools, first of all, the enduring power of attorney, the right to self-autonomy, right to self-determination and autonomy, and advanced healthcare directives. And if there's no pre-planning done, then we're looking at the detail in the bill. And I would say again, they're not mutually exclusive, because a person may have done an enduring power of attorney or may have made an advanced healthcare directive, but may not have covered or given the authority for the particular decision. So you could have a situation that both are necessary. So briefly then, looking at the powers of attorney, again, I feel it's important to emphasise there's lots of confusion, even amongst lawyers, the difference between an ordinary power of attorney and an enduring power of attorney. An ordinary power of attorney, if I'm going abroad or whatever, and I give a power of attorney to somebody to execute documents or do something or make a decision on my behalf, I have full capacity. But if I lack capacity, then that automatically comes to an end. An ordinary power of attorney, and it's used, the ordinary power of attorney is now used as an abusive tool for older people to get them to sign a power of attorney, because signing an enduring power of attorney, there are quite a number of formalities to be gone through. So it's very important that, what sort of a power of attorney is the person holding out that they have authority to act under. Just the last point there in terms of enduring power of attorney, under the new legislation, the enduring powers of attorney will be updated, but there will be an obligation now, even though the enduring power of attorney is registered, that the attorney must have regard and ascertain the will and preference or beliefs and values of the person. So even though the attorney has full authority to make decisions, same for advanced healthcare directives, there's still the obligation of that intervener, to actually ascertain for the particular decision the will and preference and the beliefs and values. Conscious of the time, there are formalities to be complied with regard to the execution of an EPA. A person can appoint a person to be attorney for their property and affairs, and now under the new legislation to make healthcare decisions, the granting and the carrying out or the continuation of treatment by a healthcare professional to consent or refuse to that. And again, people can appoint a person for property and affairs only, or for healthcare decisions, or for both, or for specific purposes of specific healthcare decision or specific property and affairs. A person making an enjoying power of attorney, execution and enjoying a power of attorney, has to go through certain formalities, and this is for protection. I still feel there isn't sufficient in the current legislation, which will be updated as well. So a lawyer is necessary to certify that the lawyer has no reason to believe that the document is being executed as a result of fraud or undue pressure. And a medical practitioner must state that the donor had capacity at the time that they were executing the document, and the donor understands the effect of that. Again, under the new legislation, there will be a wider class of healthcare professionals and indeed others who can actually give that certificate. And then the attorney must confirm that they understand their obligations. The difficulty at the moment is that the legislation does not spell out what those obligations are. The new legislation will spell out in detail. You can't transfer the donor's property into your own bank account, etc. Again, powers of attorney used as a huge tool of abuse of older people. Notice must be served on specified person. I've really dealt with that. To come into effect, the enjoying power of attorney must be registered. And the application is made by the attorney. There's an assessment of capacity of the person, and the person themselves, the donor, is notified of that application. So hopefully in the future we will see some people who have given a power of attorney where there is an application turning up in court to argue that they have capacity to make some of the decisions. And notice is served on notice parties. Again, I think that's too late in the day, and I understand, even though the bill that was published does still have that mechanism there, I understand that's been amended to bring forward those notices forward. So if there's undue influence, which is a huge issue for older people, when they're executing the enjoying power of attorney, that maybe at that stage further inquiries can be made. There are a number of additional safeguards in the new legislation to prevent abuse. Again, one of the issues at the moment is that the attorney does not have to file accounts or file reports with the Register of Wards Court. Once it's registered, the attorney really has free rein. Under the new legislation, there will be a need to report annually, and based on risk assessment basis, maybe those reports may be more frequent. So that's good. Moving on then to the issue of advanced healthcare directives in relation to consent to treatment. Just to again set out the fundamental legal principle is that a person has a right to consent to and to refuse medical treatment. And of course they need the capacity to consent to and to refuse treatment, and that's based on informed decision making, as indeed most decisions have to be based on. And I say most, very low level decisions, okay, the amount of information needed in some respects isn't significant, but obviously for medical decisions very informed decision making is requested. Again, to emphasise the fact that a person lacks capacity to decide does not mean that they haven't got the right to consent to and refuse. And that is really the UN Convention on Bioethics is really emphasising that point. And it's a point that many doctors find difficulty in understanding. So we've always looked after people who are unwell or had a disability, and so we know we will make the best interest decision. That's where I would argue with the best interest decision. I would be in favour in other respects. But it's an issue. So a person whose decision-making capacity is at issue still has the legal right to consent to and refuse medical treatment. And then if they don't have the decision-making capacity to do so, we have, again, the pre-planning tool of the Advanced Healthcare Directive. And then moving on from that, if they haven't got the capacity, then we have to fall back onto the mechanisms in the legislation, not what the doctor thinks best, really what is the best decision and how it can be made. So the legislation will define an Advanced Healthcare Directive as a written expression of the will and preferences made by a person with capacity concerning their treatment decisions that may arise in the event that the person subsequently loses capacity. So the same as an enjoying power of attorney. You make your plan when you have capacity to provide what decisions you want the person you're going to appoint to make when you lose capacity. Made by a person, okay, to be put into effect when they lack capacity. The purpose of the legislation then is to promote the autonomy of the persons in relation to their treatment choices. Extremely important. To enable persons to be treated according to their will and preference, beliefs and values. To provide healthcare professionals with important information about persons and their choices in relation to their treatment. Again, with older people, are they asked what treatment they would like or not like, etc. And again, there's a huge issue, again, coming before the House of Lords report of people just administering care, healthcare or whatever, really in the healthcare context, not asking those very important questions, which can have huge implications. And again, if we look at Australia and research that's done in terms of certain medical treatments that are administered to patients do more harm than good to the individual. Like if you take CPR and other issues like that. In addition to the guiding principles set out, as I've listed earlier in relation to capacity, there will be additional guiding principles in the legislation in relation to advanced healthcare directives. So again, the presumption of capacity and made on the basis of informed decision making. And very importantly, and this is coming up from the various cases that came before the courts here, that an adult with capacity is entitled to refuse treatment for any reason, even where it appears to be an unwise decision, or not based on sound medical principles. The doctor may have recommended you have this, and the person has cancer, you really should have chemotherapy, and the person says, really, I don't want it, and issues like that, or even where refusal may result in death. So the Jehovah Witness who's entitled to, is going to die if doesn't have that blood transfusion, has a right to refuse, even if it results in death. And again, arising from the Commission, and obviously we were writing at the time of the Jehovah's Witnesses case, added then, and the legislation follows through, the draft legislation, an adult with capacity is entitled to refuse treatment for religious reasons, even where this may result in death. Again, because certainly in the past in this jurisdiction, the whole Catholic ethos and before the courts and everything, a very important issue. So a person is entitled to refuse treatment on any grounds, maybe unwise, maybe not, sound medical principles or whatever, but they have a right to refuse. They have a right to consent and a right to refuse. So the Advanced Healthcare Directives legislation really is dealing with treatment refusals. I come on to treatment requests in a minute. So treatment refusal will be defined as valid if it and will be as effective as if it was made contemporaneously by the person when he or she had capacity. Now, I think that's a very significant provision, because the argument is that, oh, well, they made that, they really didn't, and now their circumstances have changed, etc. It's only in very exceptional circumstances. Yes, the circumstances may have changed, but that is up to looking at it at the time. It's not a reason for totally ignoring a person's advanced planning in terms of their treatment care. It's legally binding if it's made, and must be if it's a valid one, and must be followed. And again, there are civil and criminal liability, or a person now will be in breach of a statutory obligation when it's set out in the legislation. So I think that's important as well. In relation to the refusal of life-sustaining treatment, you can refuse any treatment, including you can refuse life-sustaining treatment. Obviously, the legislation is looking at the additional safeguards required there. And again, the legislation will require for a person who is refusing life-sustaining treatment in an advanced healthcare directive must have a very detailed written, not detailed, but a written statement to the effect that they understand that their life is at risk if they are refusing that life-sustaining treatment. So it's just a safeguard that's there. The person cannot refuse basic care under the Advanced Healthcare Directive, and I will come on to that as well. In relation then to treatment requests, a person can indicate what treatment they would wish to have in the future, but such requests will not be legally binding, and one may ask why. Well, it may, first of all, a doctor is not obliged, and certainly their ethical guidelines would say if something isn't clinically necessary, then doctors should not administer medical treatment if it's not clinically indicated. So in relation to somebody requesting something, it may not be clinically indicated. It may not be clinically feasible either, and it may not be practically feasible. So, you know, if I want a replacement of an organ or whatever, it has implications. Obviously, the doctor and the whole question of that clinical issue arises, and the assessment of that and whatever. However, there will be a detailed code of practice in relation to the whole question of advanced healthcare directives, and that code of practice will set out, insofar as possible, of course, persons' requests and healthcare planning in terms of looking for treatment or whatever will be taken into account where that is possible. So it's not that it's going to be totally ignored. The whole question then of access to the Advanced Healthcare Directive under an enduring power of attorney, there's a formal register in the High Court currently, and that will continue. Where it'll be in the new regime, I don't know, but anyway, there is a formal register in relation to advanced healthcare directives. Obviously, healthcare professionals need access to that, and again, various suggestions were made in the submissions how to achieve that. It could also be registered with the register in the High Court with the enduring powers of attorney, but equally there should be a practice. So medical professionals asking a person about signing the consent form or whatever, have you made your advanced healthcare directive? And our public health card or our public service card should have our little information on that. So hopefully technology will assist as well. A person can also appoint what is termed in the legislation, which is a bit of a mouthful, a patient-designated healthcare representative. So effectively, a person can make an advanced healthcare directive, doesn't have to appoint a patient-designated healthcare representative, can literally write down what their wishes are and have that available, or they can appoint somebody to make either limited decisions, limited to just ensuring that their wishes are carried out and that their wishes are properly interpreted, or give a general authority to the person, the healthcare representative, to actually consent to or refuse treatment up to and including life-sustaining treatment. So the right of a person to appoint or nominate somebody else to do that. The new legislation on advanced healthcare directives will not affect the criminal law on euthanasia or assisted suicide, but again, that's a policy decision in terms of, and a conversation that we in this society have to have in view of the recent cases, etc. But the advanced healthcare directives is basically, and it's fundamentally, providing for a situation, a mechanism for when a person lacks the capacity at the time the decision has to be made. It's putting in place that mechanism that they can do so. So they can set out in advance what their wishes are. And that is, again, coming back to the UN Convention on Bioethics, to ensure that states have that mechanism in place. So in relation to basic care then, I said that a person cannot refuse basic care. Basic care is not medical treatment. It's normal warmth, shelter, oral hydration and nutrition and hygiene measures. So a person can't say, just neglect me totally, or don't feed me, or whatever, or don't give me comfort. So it's important. Again, talking about comfort and palliative care, the Commission was recommending that palliative care should be included in the definition of basic care, just to make sure that people get it. But of course, palliative care again isn't available throughout this country at the moment, so that's another issue. So we need to look at the Council of Europe recommendation in relation to older people recommends that palliative care should be available on a nationwide basis. Then I raise the question of what really is medical treatment. And medical treatment is, of course, includes artificial hydration and nutrition. And that is a very difficult topic. And many people, the whole question of asking next of kin to actually, who are very anxious to keep their parent alive or their next of kin or their loved one alive at all costs. So in other words, artificial hydration and nutrition, which actually, again, on the other side, where people, say the medical professionals, are not maybe as educated in terms of end of life. The doctors are very well trained in treating people, curing people, but not as trained, I say, up to the standard that they should be in terms of assisting people to die naturally and to die well and to die very comfortably. And then as a society and as a community, we don't understand actually in demanding that artificial hydration and nutrition, it can be a very painful death. Rather than actually very appropriate palliative care being given. I even heard recently when we were giving a briefing to members of the House of the Oireachtas, and one TD saying, we always accused my brother for actually my mother, she was the cause of my mother's death because he actually gave consent for a do not resuscitate order. So that's how, misunderstood the whole situation is. One, no, and it happens, Matt Cooper, I don't know whether you said Matt Cooper the other day, talking about he had to consent, he was asked, he was left with the decision of do not resuscitate for his parents. He had no authority to consent or to refuse or whatever in relation to that. So we've a whole confusion around that. So we need to understand those issues. And there are clinical and ethical decisions to be taken at end of life. And again, the Ombudsman report last year, I was interested in terms, the Ombudsman report, he did a report on end of life care. And his findings were the whole question of communication and the lack of appropriate communication with families and next of kin, relatives or people about people dying. And he gave examples actually where there was poor communication. And interestingly enough, in a number of cases, it was all around the do not resuscitate. And he found that actually the clinical decision was the right decision in the end. But actually, I felt the whole communication problem of asking a family to sign a do not resuscitate order and then the family not understanding that really they shouldn't, and the correct clinical decision was a do not resuscitate in the particular circumstances to give that palliative care and enable the person to die very comfortably. So I know Sean will talk about this later, has been studying do not resuscitate orders in great depth in the recent past. I move on then very quickly to the physical and chemical restraint. Physical and chemical restraint is not medical treatment, and certainly there are in the European Convention of Human Rights in terms of right to liberty and all of that, and it will spell out the circumstances in which a person can be deprived of their liberty. And one is if a person is very mentally ill, and the Mental Health Act gives the definition of a person with a mental disorder. If they're going to do harm to themselves or another person, then they can be restrained. And under the Mental Health Act, there are very detailed rules and regulations set out by the Mental Health Commission in relation to how that is to be, the least possible time, all of the rest. For older people in nursing homes who are restrained, where is our Human Rights EU Convention? And again, the EU Convention clearly sets out any restraint must be in accordance with very clear laws and rules. And we don't have it. We have a huge deficit, and the bill is hugely deficient in that regard, in the sense that it doesn't deal with the whole question of restraint of or deprivation of liberty. Again, looking at, say, England, where they have huge regulation in relation to polypharmacy, etc., particularly with older people, and it's regulated and the reviews are required. In this jurisdiction, we don't have that. We have, again, I hear through the grapevine in terms of GPs being asked to go into nursing homes to quieten somebody down. Certainly, again, the whole question of chemical restraint. It's not required. The chemical restraint is given to control behaviour. It is not given because the person needs it for a medical condition. Again, huge research done in Australia, Canada on the whole issue of chemical restraint, which proves that giving it to older people who have other diabetes, other cardiac issues and all the rest, does very much more harm than anything else. So we've a lot in this jurisdiction to talk about, to face into and to deal with properly in actually seeing what the issues are. And again, in dealing with older people and family members, have to challenge, ask questions, sage advocates. So there's a lot of work out there to be done on the ground. The last then issue there on who makes decisions when they haven't. So the clinical and ethical decision is very important. If nobody has that authority or whatever, that's where you need very clearly trained healthcare professionals to understand the issues. I see I've hugely run out of time, so just in terms of then, if we haven't the pre-planning done in terms of the bill, there are three different. There's decision-making assistant, which is a personal appointment by the person, but needs assistance in getting information and interpreting the information. The next level up, the legislation is planning, and this is taking account of the different levels of capacity. A co-decision maker. When the bill was published, it talked about oversight by the court. Whether that, in the end of the day, arises, I don't know. But all I would say is huge abuse and safeguards are necessary. So. Undue influence, and then where a person simply hasn't got the capacity at all, and even with assistance will not have the capacity, then it's court appointment. The court itself can make once-off declarations or orders or whatever. There will be provision for court friends, experts, special and general visitors, all of that. Again, the whole question of will and preferences and beliefs and values, and the least minimalist intervention insofar as possible. Wards of court, there will be a review of wards of court which must be carried out, and current wards will be discharged if they're found under the new assessment of capacity, or the correct assessment of capacity, if I can put it that way, to have capacity. And we all know there are wards, people who are in wardship at the moment who actually have capacity to make many decisions. Just very briefly, again, a tool of abuse, I feel, is the whole question of joint accounts at the moment, which are used. And, of course, a joint account can be used between husband and wife, and the whole intention is that it be shared. On the other hand, for older people, where an account is put in joint names, again, that is simply an agency account. And huge abuse on that particular issue, which again NCPOP have done a lot of work on, and they published very recently Take Control of Your Finances for Older People, and if you go in on to the, that's UCD and CPOP, National Centre for Protection of Older People. So again, that has to be addressed. State pension is a huge issue then, in terms of it can, family members collect that and think it's their own, for their own use. And then the whole question of gifts and improvident bargains, again, and the Law Society, thankfully, in 2013 had introduced regulations to ensure that solicitors didn't act on both sides of a voluntary transaction. And that only passed the Pippin Post by a very narrow vote. And you had NFA and our Criminal Milk Suppliers Association, all of these people out saying all lawyers were doing was looking for money. On the other hand, we at the background were trying to push this to make sure that actually people weren't signing their homes or their farms or whatever over, or their businesses, and to make sure that they're provision for themselves. So anyway, just say there on the slide, deprivation of liberty, the whole interface between mental health and mental capacity needs to be properly addressed, and other issues. So sorry for that gallop through, and just to put out the two issues there of SAGE and the Think Ahead project, which I think are hugely beneficial for older people. Thank you.